And you're very welcome to the House, Minister. At the outset, I want to express my empathy and heartfelt compassion for any mother or child that suffered in any institution. I say that not only as a senator, but also as a mother and a foster parent. I want to put on the record of the House that I appreciate the important work of the Commission in investigating the matters within their terms of reference and drafting a final report with their findings of fact. The records and reports of the Commission will, I expect, be an extremely valuable resource. I am sure all members of the House can agree on these 3 points. I am sure that all members can also agree with the principle that if someone says something to them in confidence and an assurance of confidentiality is given to that person, then it should be honoured. I am sure we can all agree that is honourable and the decent thing to do. The amendments proposed by Senators McDowell and Boyan honour and give effect to legal commitments of confidentiality given to people and also are in harmony with the existing legislative framework of data protection and associated fundamental rights and freedoms. If we look at the statutory instrument that established the Commission, it clearly states the Commission shall not seek to provide an account of any individual case in such manner as to intervene in any effort by any individual to resolve their identity or trace a birth relative. The statutory instrument also states as follows: the Confidential Committee shall provide in its procedures for individuals who wish to have their identity remain confidential during the conduct of the Commission and its subsequent reporting. Of course, I have sympathy for all those seeking to trace a birth relative or to resolve their identity, and I understand legislation is going to be introduced by the Minister to address this in the future. I also think that we should honour the commitment of confidentiality enshrined in law given to witnesses that gave testimony and helped the Commission. It would be a betrayal of these people and these women and these mothers who assisted the Commission on that basis to renege on that. The amendment proposed to Section 2 of the bill by Senators McDowell and Boyan is necessary to ensure they are protected. We cannot, in good conscience, permit records created by the Confidential Committee to be deposited with Tusla in an unredacted format without the explicit prior informed consent of the person that gave that evidence. The deletion of Section 5 of the bill and the replacement of it with the amended Section 5 drafted by Senators Boyan and McDowell is also necessary to give full effect to the legal guarantee of confidentiality given to people participating in the work of the Confidential Committee. The Commission should have the power set out in this new Section 5 to redact personal data of those people who gave evidence in confidence. Finally, I think it is in the best interest of the Commission and all those involved in the work to defer dissolution until the 30th of November 2020. I think we can all agree that the administrative work of the Commission is too important to be rushed. For this reason, I support the amendment to Section 6 of the bill put forward by Senator McDowell and Boyan. I respectfully ask my colleagues in this House and to consider supporting these amendments number 2, 7, 21 and 23 on the numbered list, which honour commitments of confidentiality that were part of the legal foundation of the Commission in the first place.
Look, I beg Senators' indulgence on the details on this. I had a conversation late last night with the Attorney-General where I asked him to start work on this. We've been here since, actually, my phone went off very rudely at the start of this, and it was the Attorney-General looking to talk to me, and most of this morning was spent preparing for speaking with you today. So I don't have the firm details of that at this particular stage. But I'm happy to make that commitment to Senator McDowell that when the draft amendment is out, I'll ensure that it's supplied to Senators so Senators can scrutinise it as such. As regards the database and the what is the harm in allowing the database rest in the archive until such time as information and tracing legislation comes out? I suppose and Senator Batchik, and I kind of went back at Senator Batchik at that, but she did make the point it didn't get delivered in the last Dáil, and I don't think any of us think the information and tracing legislation will be something that's done quickly. Shouldn't be done. It should be done right and given the appropriate length of time. And the database does provide a benefit now. It will provide a benefit to Tusla in its existing functions. We all know they're inadequate as regards information and tracing, but it will provide a benefit to them. And I think that benefit, plus the certainty that it's not in the archive, is worth passing this legislation for.